Imagine this scenario. A client hires an attorney to represent him in a legal dispute. The attorney negotiates, provides advice, and handles the case. But what if the client begins to suspect that the attorney's behavior has been negligent or even fraudulent? Today we delve into the fascinating case of Mr. Francisco Gomez Gonzalez and his former attorney, Mauro Jordán de la Peña, and the series of events that unfolded during a legal dispute with AvaTrade. In the initial stages, Mr. Jordán de la Peña was negotiating with AvaTrade to secure 75% compensation for Mr. Gomez Gonzalez. However, despite these negotiations, AvaTrade filed a lawsuit against Mr. Gomez Gonzalez in Murcia and before the WIPO, claiming several web domains. Mr. Jordán de la Peña advised Mr. Gomez Gonzalez not to respond to the WIPO lawsuit, asserting it was unnecessary and there would be no repercussions. He also indicated that Mr. Gomez Gonzalez would need to pay 2,000 euros for each domain to defend himself in the WIPO. When it came to the Murcia lawsuit, Mr. Jordán de la Peña suggested that Mr. Gomez Gonzalez simply apologize at the conciliation hearing, without considering the legal implications of such an action. Furthermore, he failed to inform Mr. Gomez Gonzalez about Article 456.2 of the Spanish Criminal Code, which protects complainants from being sued until the original complaint is resolved. Mr. Gomez Gonzalez also noticed inconsistencies in the documentation presented by AvaTrade, such as the lack of authenticity of the Hague Apostille and the absence of information about Mr. Ferguson, AvaTrade's representative in Europe. The actions of Mr. Jordán de la Peña raise serious questions. Was he negligent in his duty to provide adequate advice, especially concerning the WIPO lawsuit? Did he misrepresent the costs of defense before the WIPO, leading Mr. Gomez Gonzalez to believe he had to pay an excessive amount? Did he fail to present a strong defense at the conciliation hearing of the Murcia lawsuit, exposing Mr. Gomez Gonzalez to potential negative legal consequences? And could there have been malpractice? Did Mr. Jordán de la Peña fail to inform Mr. Gomez Gonzalez about the protection offered by Article 456.2, which could have prevented AvaTrade's lawsuit? Did he neglect to question the authenticity of the documentation presented by AvaTrade, indicating a lack of due diligence? The actions of Mr. Jordán de la Peña have evidently caused significant harm to Mr. Gomez Gonzalez, both financially and legally. It is recommended that Mr. Gomez Gonzalez seek independent legal advice to assess his options and consider filing a formal complaint with the Bar Association. In conclusion, this case serves as a stark reminder of the importance of ethical and professional conduct in the legal profession. Attorneys hold a position of trust, and their actions can have far-reaching implications for their clients. As we've seen with the case of Mr. Gomez Gonzalez, failure to uphold these standards can result in significant harm and potential legal repercussions.